Welcome to the Grow Your Business and Grow Your Wealth podcast with Gary Helt. Gary is an expert in helping business owners put together a plan that will provide a better future for their businesses, themselves, and their families. On the podcast, Gary interviews other professionals who share his vision, and together they share secrets and strategies any business owner can use to build a better financial foundation for your business and your life.
Hey, welcome back to the podcast. This week, my guest is Jamaal Stafford, who's the founder and managing member of the law firm of J.W. Stafford. Welcome.
Hey, thanks, Gary. Thanks for having me.
So, Jake, tell me, what is it about law that made you get involved with it?
Yeah, look, I grew up as a kid watching, all the legal shows. But law is one of those areas where it touches everything. It touches business, individual, relationships. And it's just one of those areas where it's just very interesting and you really can make a difference for, everyone from the big Fortune 500 companies to the individual, living next door. It's just a really very important aspect of our country. And I think it's one of the great things about America. I mean, you can ideally get equal justice under the law. So I like it. And this is what I've been doing for 15 years, something like that. So.
Right. Now, your firm specializes in employment law, right?
Right. Employment law. And we also represent licensed professionals in front of their professional licensing board. So like doctors, nurses, dentists who may have issues that pop up in front of their board. But yes.
Okay. So what is it about the employment law and stuff that really gets you excited, and why is it that you chose, that particular niche?
Yeah. So employment law. So let me back up. When I first came out of law school and finished my clerkship, I worked for a big Fortune 500 company, working for just corporations. The individuals we spoke with were more of a general counsel, and so I wanted to sort of get a little bit away from that and to start helping individuals. There's nothing more fulfilling than to help people. And so with employment law, I'm able to represent individuals and also represent businesses. So we actually do both sides. We do management side and employee side. And we think that gives us a unique perspective because we know what the plaintiff's lawyers, we know the angles that they want to take. And we've seen, obviously how businesses sort of run afoul of things, and we can help them in various areas in the employment context. So, yeah.
Right. So, again, so you're kind of doing both sides. So,
Yep.
That does kind of give you a unique perspective because of, hey, well, if I was doing this is, you kind of know the counteract and everything else that goes along with it.
Yeah.
We'll start out with, from the business side of things.
Sure.
What are some of the common mistakes that you see businesses make when it comes to, their employees and employment law?
Yeah. So it's a few things. One, we see, especially smaller businesses, they're not very good at documenting performance management issues. And what we see happening a lot of times is, a smaller business, you don't want to be too critical sometimes. And so an employee who's got serious performance issues, personality issues that, create conflict in the workplace, they're not documented like they should be. And what happens a lot of times is that employee is going to be the one who goes to the EOC,
right,
and says, you discriminated against me or what have you. And what happens is if you don't have that documentation in place, like, hey, we've provided a verbal warning about X, Y, and Z, and here it is. If you don't have that documentation in place, you're sort of at a disadvantage because when you go to explain how poor of a performer this employee was and the issues that this employee was having, the first thing that's going to be asked is, well, where is the write-up? Where is the disciplinary document? Where's the documentation? And so we really see small business owners especially make that mistake. And so that's definitely something that you've got to do it. You've got to do it consistently. You've got to be very as clear as possible in those documentation. If you have an employee who has performance issues, you need to document that well and make the employee sign it and acknowledge that, look, hey, we've showed this document to you. You are on notice. And if they refuse to sign it, say so there on the document. So that's one area where we see business owners make mistakes. Another is the wage and hour context. It doesn't happen often, but it happens. Wage and hour issues are what I'll call a very plaintiff-friendly area. There's in the wage and hour context, it's a very clear calculus for plaintiffs' lawyers. Is there liability? And if so, it's off to the races. And so you want to be careful here. You want to make sure that you've got electronic timekeeping records. You want to make sure that you appropriately classified these employees that are working for you. And so you really want to make sure you've got that lined up, because with wage and hour issues, there is the possibility for individual liability. So, for instance, Gary, if you had, let's say an assistant, and he or she worked more than 40 hours a week and you didn't pay overtime, yes, your business could be subject to a lawsuit, but also you potentially could be subject individually to a lawsuit. So it's very important that you get those, get the wage and hour issues, is correct from the beginning, and make sure that you've got everything, obviously time records kept appropriately.
Right. Now you talked about classifying employees and stuff like that, and then you're talking about kind of the overtime and stuff.
Yeah.
I know lots of times people think, oh, well, I put them on salary, so I don't have to pay them that. Can you talk about kind of the classification of employees and how that does differentiate?
Yeah. So it's like it is an analysis. It's not something we can
Right.
really do on this, but it's one of those situations where, depending on what the employee does, job duties, responsibilities, you've got to make sure that the employee is appropriately classified as either exempt or non-exempt. And so you want to make sure that's done right. And look, we recommend, look, obviously your payroll company has some, generally speaking, depending on who you work with, has, basically job categories that can help you sort of figure that out. But, look, depending on what you've got this individual doing, you may need to get consultation with an HR professional or an employment lawyer to really sort of sift through, is this person being classified appropriately? So it does get into the it can get into the very nitty gritty sometimes. So you got to be very careful on this.
I think it's, something that's important. I always talk about, hey, it's better to pay that professional up front than it is later on, because when you're paying it later on, you're paying exponentially more.
Yeah.
When somebody, because lots of times when people start their business, it's just them. And then next thing you know, they need to hire that helper or somebody in the office or whatever. And then next thing you know, they got 5 and 6 different employees and so forth. How does that look when somebody comes to you and say, okay, I'm coming to you now because I've never really had anybody classified. in any particular way. I'm not doing performance reviews and stuff like that. How does that look, coming to you, and how do you guys then take and help me kind of get my employment house in order?
Yeah. So a few things. One, that is the typical small business. And look, I mean, it's not unexpected. It's a typical small business. What we like to do at our firm is we say, look, we want to get involved when it's, obviously we are there to provide advice and counsel when appropriate. But the first thing we would probably do is say, look, you need to get an HR professional, an outside HR professional. So for instance, Heather Dunkerley
Right.
is on our board. We absolutely would refer that out because it's more cost effective. There's, a lot of that stuff is you just need an HR professional to help you and to get it in order, and they can do that in a very cost effective way. We like to get involved when there is this sort of, hey, look, we've got potential litigation here. We need to get involved where there's a concern about litigation. You've gotten a letter, an employee maybe has said something that sort of sparks oh my gosh, we might have a lawsuit coming. Then we want to get involved. But, for getting the house in order, a lot of times an outside HR professional can be a very cost effective way of doing that. And we're all about that because, look, they've got, it's more cost effective for a small business owner to do that.
Right. I think it's important also to, and you're saying about the HR professional, because, there's many, CPAs, accountants, bookkeepers that actually do payroll.
Yeah.
I do payroll for people, but I am not an HR person. I do not classify people's employees or anything else. You tell us what to pay, and that's what we pay.
Yeah.
So it is important to make sure that you're doing that classification properly and things like that, because I know people have come to me and they're like, oh well, I need help. It's like that's not what we do. And I will tell you, probably 99.9% of the time a CPA is not the right person to go to for when it comes to these classifications. We look at it more from is somebody an independent contractor versus an employee, because of how we have to report stuff. But outside of that, and there's still some gray area in there that I think people need help with.
Yep.
Let's turn the table here and talk about that employee who feels that they've been classified wrong, or they're not being paid the proper wages, or they've decided that with the quiet quitting movement that has been upon us and stuff like that. What are some of the advice that you give to these individuals that fall into this category?
Oh, for the employees?
Yeah, on the employee side now.
Yeah. So it depends. So let me give you so for instance, the wage and hour issues, right. Employee comes to me and says, look, I'm not getting paid overtime, or they're paying me straight time, not time and a half. Look, we obviously behind the scenes try to get as much information as we can. And then at that point, once we've determined if there's potential liability, we then proceed accordingly. Look, so that's the wage and hour side. I mean, but look, there's so many employees come to us, and I will tell you this, we probably meet with 30 to 40 employees a month in consultation. We probably only accept 5 to 10 a month. I mean, look, employees come to us about almost everything, whether it be from, they believe they're being discriminated against, they believe there's compensation issues, etc. And we try to, as a firm, to really sort of sift out as much as we can, like, hey, do we have something here that is meritorious? And if so, we try to absolutely move it forward. But look, a lot of times it's sort of like giving the employee advice on what to do. And we stay behind the scenes, and an employer may never know we were even doing anything. Help the employee craft an email, complaining to HR about potential discrimination, something like that. But we try to, it all is dependent on the circumstances of the employee, what their comfort level is with us being out there. Because look, there's a lot of times where, depending on what's going on with the employee and the issues they're complaining about, it may not make a lot of sense for us to get involved, because once the lawyers show up, the relationship changes. And that's something we really try to press upon employees. We want to be judicious about us sending a letter over.
Yeah, I mean, I think it's important too that lots of times people are happy where they're at. They like what the job is that they're doing, but it just may be they don't know how to communicate the right way. Like you're saying, hey, I'm working, 60 hours, a week, but I'm only being paid for the 40, or maybe I am being paid for 60, but I'm not being paid the time and a half. How do I go about making sure that I get compensated for this? But you're right. I mean, if once the attorneys come in, I mean, that changes, things big time.
Yeah. Yeah. And look, when it comes to the compensation, wage and hour, we're not very shy about getting involved in that, because that's your money.
Right.
When we're talking about discrimination, that's where we get real, I'll call discerning, because look, people have different, people interpret things differently, right? They'll interpret the boss speaking to them or not speaking to them a particular day, and it may be like, look, the boss is just busy, but they take it, they interpret that differently. And so we really do get judicious about the discrimination aspect. But wage and hour, and this is one of the things that I really, really impress upon employers. Look, plaintiffs' lawyers love wage and hour cases. No doubt about it, because once there's liability, once that's clear, any employer, any employment lawyer, especially on the management side, will tell you, if there's clear liability, you want to get that wage and hour case solved as soon as possible,
Right.
because you've got attorney's fees involved. And what can happen, and I'm telling you, this does happen. You fool around and you don't get this thing resolved, this case, the wage and hour case resolved. You may owe the employee, say, $30,000. But the attorney's fees, you fooled around and you let this attorney file suit, go through discovery, go through a trial. Those attorney's fees can be $80,000, $90,000, $100,000. So it's like, you want to make sure that you've got those ducks in a row. And if there's a problem, you want to get counsel involved early and get this thing resolved early, because this thing can spiral out of control. It can be very, very expensive, very expensive. Yeah.
Right.
Yeah.
Kind of jumping back to the other side, management side,
Sure.
again, the quiet quitting movement and stuff like that.
Yeah.
What's kind of, growing up, I was always taught, if you're working 8:30 to 5, that means you're at your desk, your computer's on, you physically start working at 8:30, not you come rolling in the door at 8:30. And then, at 5 o'clock's the, quitting time. It's like, okay, I'm not walking out the door at 5 o'clock. I'm working and then doing everything. How, because this is a big topic for a lot of people.
No, look, I'm telling you, and I think every employer will tell you, look, the way that the employees, at least folks I've spoken with, the way it usually works, the employee comes in, whether on time or late, and the first thing they're doing is they're checking TikTok. And they're checking their social media. It's I'll tell you, it's a different it's a different generation, and I think it is generational. And again, not to sort of lump everybody together, but there's generational stuff going on here. And the challenge for employers, but also the opportunity, is that, look, you've got, look, you've got sort of a very small pool of available employees right now. I mean, it's a challenging time to find an employee. And so you've got to figure out, some employers are trying to sort of figure out how to make it work, right? Look, you've got employees who are into social media. Look, is there something you can do to, sort of one, help capture that? Because look, they can be a good source of, look, if they like working for you, hey, nothing better than them blasting it out on social media. And so figuring out how to sort of, yes, you got to get your work, you got to get the work done. You want to have standards, but trying to figure out how to work with it a little bit. That's my recommendation. But look, I mean, there's going to be some times where you've got to, and this can be maybe putting policies in place. And because one of the things as well is, look, as you're growing as a company, you go from one, employee of one being you to 2, 3, 4, 5, maybe 100, whatever. Hey, look, having that employee handbook in place. So like, look, you can point to, hey, this is the policy. We need everybody to follow it. And to really try to get that, like, look, here's the standard, here's the policy, but don't lose sight of, like, you got a different employee pool here. You sometimes you may need to sort of work with it. I think I was talking with somebody a few days ago, and back in the old days, employees would take time out to go smoke, right? Like it was that's just what happened, and so it's like it's a similar issue with this social media stuff, right? Employees, they're not going out smoking, but they're going to look at social media.
Right.
Yeah.
Right.
I don't know which one's worse. I mean, I don't know. I mean, but
Right.
But yeah. So yeah.
So, I guess kind of circling back here, the whole if somebody's working or whatever, is your hours are 8:30 to 5. You get your half hour for lunch. Is it based on them showing up at 8:30, them leaving at 5, or is it actually work?
Well, yeah.
And
So
two pieces here. I mean, obviously, I'm asking you more on the legal side. Yes, on a do you really want to keep the employee side? You got to do something within reason. But just wondering from a legal side, what is the real rule there?
yeah. So one, if it's obviously an hourly employee, it's generally you. Let me say this: if they show up 8:30 and their lunch is at 12 to 12:30, what have you, they're essentially, again, there's some exceptions, can get real nitty gritty, but 8:30 to 12, like they're on the clock, right? I mean, like it's that's what we look. We I don't know a situation where if they're from 8:30 to 12, they should be working, right? I mean, they should be working. And it's like one of those things where it's like, I tell employers, look, you want to be very careful about fooling with those hours. Look, because if they're there from 8:30 to 12, they're working. They should be. Now, if they're not, then you need to, and it's something that, look, they're just not working, they're not being productive, then, you need to, do disciplinary actions pursuant to your policies. But you got to be very careful about fooling around with these hours. And I'll tell you, look, I had a client a while back, they would fool with the hours a little bit. And that's a recipe for disaster. You got to be, if they're not working during that time period they should be working, then you need to do disciplinary action. But you don't want to open yourself up unnecessarily to a wage and hour claim, fooling around with hours like that. That's not, especially, no, you don't want to do that. That's a recipe for disaster.
Right. So don't dock, you're saying don't dock their time, make sure you
No,
pay them and then just work on
pay him.
the
Disciplinary
disciplinary
side.
side. And
Yeah,
then,
yeah, yeah, yeah.
if you
Yeah.
gotta, you document it. If it's time to get rid of them, then, you gotta make sure you have the documentation.
Yeah. I mean, because that's the cleanest way to do it, because I'm telling you, you start fooling around with, you don't want to get tied up in wage and hour litigation if you don't have to.
Right.
Not to save what? To save
Oh
30
yeah.
minutes of
I mean,
time,
in the grand, and I think sometimes as a business owner, it's more the principle of it. Hey, look, you're supposed to be here working at 8:30, not rolling in at 8:30 and getting your cup of coffee and talking to all of your people, and then maybe you finally turn your computer on at 8:50,
Yeah.
type thing. So I think that's there's definitely ways to handle it.
There
Uh,
are. There are.
and I think it's a little bit harder right now with the way our the people that are out there that are qualified or unqualified to do these jobs.
Yeah.
And everybody seems to be having a hard time finding the employees, to especially if you want them to physically come into the office to work. That's for
Oh
sure.
yeah. No question.
Yeah.
No question.
So
Yeah.
I mean, Jay, so we've covered a lot of stuff here. Short period of time. I know we could probably go on hours about different scenarios and things like that. What have I not asked you that you wish I had?
Yeah. EPLI insurance is something I think that
That's
business
good.
owners, yeah, employment practices liability insurance. So it's one of those things where it's like, depend on your insurance broker, they may or may not mention it, but it's something I think to have a conversation about, because as you get more employees, it's just more risk, more opportunities for folks to, look, nothing stops an employee from going to the EEOC and filing a claim.
Right.
Uh, you know, eh, Nothing stops an employee from filing something with the Department of Labor saying, so EPLI insurance can be a good way of just having a little bit of coverage to help, defend you, get a defense lawyer involved to
Right.
protect you a little bit should you have to go to the EEOC or have to deal with some type of employment dispute. So definitely something to think about. You should talk to your insurance broker about it. See what the rates are. Because again, once you start getting beyond an employee of one scenario, it's something that you want to potentially start thinking about, because as you grow, again, you start hitting certain employee numbers, you start becoming subject to more laws.
Right.
And look, one thing I can tell you in Maryland, in DC, you've got to have your ducks in a row from a compliance standpoint, and you need a backstop, because once the litigation or threatened litigation starts, paying for a defense lawyer can get real expensive real quick. So definitely EPLI, I think, is
I think,
something.
yeah, because I think that's I'm going to say that's peanuts compared to
Yeah.
what it could be.
Yeah.
And I think that, like you're saying, once you get to more employees and stuff like that, because, like right now, something could be going on out there between two employees that I have no knowledge about,
Yep.
but I'm still held liable because I'm the owner. So I think that's a great recommendation, for anybody out there. Jay, if people like what they've heard and they would like to talk to you on either side of it, from a management
Sure.
or an employee side, how can they reach out to you?
Yeah. You can call us. Our number is 410-514-6099, or visit our website, www.staffordtrialteam.com. Be more than happy to speak with you.
Great. I really appreciate your time today. I think people have learned a lot from this. I think that this is something, as a business owner, especially when we've started out and it's just been us and we've grown, we're not thinking about. That's
Yeah.
for sure. So I really appreciate your time today.
Yeah. No, thank you, Gary. Thanks for having me.
Great. Hey guys, this week our guest was Jamaal Stafford, who's the founder and managing member of the law firm of J.W. Stafford. I will see you guys next week.
This show has been produced by Market Domination, LLC. To discover how you can have your own show completely done for you and turn it into a real published book and become the authority in your marketplace, go to www.marketdominationllc.com/podcast offer.